Hello. Welcome to the CCI-Toronto's annual case law update. Now, I wish I could tell you that 2021 has been a year like no other, but personally, I found this year looked a lot like last year. So if you felt the same way, know that you're not alone. And if you are alone or you have friends or neighbors who are alone, I hope we can reach out to each other this season, even if it's virtually, so we can stay connected and try and keep our spirits high, even if your holiday parties end up getting canceled or cut down. This event, the CCI Holiday Event, was in particular always a fun event for me. And while I'm sorry we can't get together in person this year as the pandemic rages on, I'm pleased we're here virtually. So after this session, we will be asking for your thoughts on the session, and we'd love to hear anything you'd like to tell us about the programming or the content we're delivering. And also, we'll be sending a link out to everyone with a video of this event in a few days' time. So in this session today, we have 3 condominium lawyers discussing hot topics and recent cases. Before we get there, I would like to introduce everyone to the new platform AirMeet, just in case you haven't been on this platform before. So throughout the session, we encourage you to send us your questions through the Q&A feature, which should be at the bottom right-hand corner of your screen. Also, we're going to be doing a few polls throughout the session, and the polls tab is next to the Q&A feature. So when there's a poll, we'll ask you to give us your thoughts, and we'll survey the crowd to see what you think about some of the topics we're speaking about. Now, if you experience technical difficulties, if you can't hear us or see us, there's a People tab on the right-hand side, and please communicate with the event staff. You can send them a private note, and they will be able to assist you. And lastly, because this is a holiday season, we have a couple of giveaways, and we will be doing a draw after our speakers finish, but before the questions. And only those who are here today will be entered into the draw and eligible to win the prizes. So make sure you stay to the end of the session. And lastly, I can't get started without thanking our CCI Toronto sponsors who helped make today's webinar possible. They are Duca Property Management, Gardiner Miller Arnold, Macintosh Perry, RJC Engineers, Wilson Blanchard Management, Scion Coulter Engineers and Building Specialists, CWB Maximum Financial, Edison Engineers, Malvern, Normac, and Suncorp Valuations. Now, let's get to the webinar. I am going to introduce you to our 3 expert condominium lawyers who are here today to give you their thoughts and tell you about the cases that have changed the legal landscape. We have Francesco Deo, who is from Deo Condominium Lawyers. We have Nguyen from Gardiner Miller Arnold. And we have Ben Rutherford from Rutherford and Mathews. So the first thing that I would like to talk about today is the Condominium Authority Tribunal. Most of you probably know this as the CAT. So this is a dispute resolution body that was created several years ago. And it started out just dealing with access to records. And it has been slowly expanding its jurisdiction. And as of January 1st, it will now deal with disputes about noise, odor, light, vibrations, smoke, and vapor. So, while 2021 did look a little bit like 2020, I promise you that 2022 will be completely different if you're someone dealing with noise and smoke in your condominium. So, let's take a look at some of the decisions that the CAT has released this year. And I'm going to turn to you first. I know that the CAT doesn't just deal with residential issues. Can you tell us a bit about a case brought by a commercial owner?
Thank you, Megan. Hi, everyone. All right, so the first case I want to talk about today, it's called TW Cross Investments Ltd. And Peel Standard Condo Corporation 1052. So this ties into what Megan had talked about, the expanding jurisdiction of the CAT. So in this scenario, it was a commercial property, but the CAT, it was a case about the jurisdiction over a declaration amendment regarding a provision that governed pets. So in this case, TW Cross, the applicant, filed an application with the CAT in which it alleged that the Condo Corporation didn't follow the requirements set out in the Condo Act when it amended its provision to, its declaration provision relating to animals. So what the board did was they passed a resolution to amend the declaration to allow units to be used as a vet clinic. Previously, the declaration only allowed guide dogs and assistant dogs in units. They proposed the amendment. It was circulated to owners, and after 80% of owners consented to the amendment was registered on title. Now, TW, the applicant, wanted the CAT to declare the newly amended section to be invalid and enforceable, and the condo to apply to delete it from title. The condo brought a motion to dismiss the application before hearing the evidence because it argued that the tribunal didn't have jurisdiction to decide the amendment process. So they said that the application is not an issue about pets or animals, because at this stage, the CAT has jurisdiction over pets and animals, but it was actually a process issue about Section 107 of the Act, which sets out the requirements of requirements for amending the declaration. The condo argued that the tribunal's jurisdiction did not extend to Section 107 of the Act. But the CAT dismissed the condo's motion because the overall crux of the dispute dealt with a declaration provision prohibiting, restricting, or otherwise governing pets or other animals in the units, which is squarely within the CAT's jurisdiction. So the CAT said, despite the procedural issues raised by the applicant, the CAT said that nothing prevented it from considering a procedural matter in determining the validity of the provision, because the Act states that the tribunal has exclusive jurisdiction to exercise powers under the Act to determine all questions of fact or law that arise in any proceeding before it. So the condo's motion was dismissed and the hearing was allowed to proceed in the CAT. So the takeaway is this case demonstrates the breadth of the CAT's jurisdiction. If a matter relates to pets, vehicles, parking, and storage, and soon in 2022, noise, odor, smoke, vapor, light, and vibration, or procedural matters that relate to these topics, then it will likely fall under the jurisdiction of the CAT.
Thank you, Anne. Yeah, I too have found that if there's a question whether or not the CAT has jurisdiction, it seems to have jurisdiction. So thank you for those comments. Francesco, I'd like to ask you about a case. In particular, I know that a lot of us here, owners, provide the board with different types of contents. Can you tell us a little bit about a case where a condominium needed to verify some of these statements?
Yes, and thank you, Megan. Hello, everyone, and thank you for attending our webinar here today. So I'm going to talk about Tscc 2370 versus Chong. This was a case that was argued by my colleague, Maria Demakis. This is another CAT case about a dog, ironically, and this is a topic we probably all know way too much about. So this barking dog case fell within the Condo Tribunal's new jurisdiction. And it gives us an idea as to how the tribunal might interpret a condo's declaration and rules going forward. So let's start with the facts. Mr. Chong was an owner of a unit, and it was actually Mr. Chong's tenant who had a dog that was causing the issue in the unit. So the tenant had 2 dogs, and in March of 2021, the condo began receiving complaints of barking in the unit. And over the course of the dispute, the condo received about 48 documented complaints of loud barking in the unit. So in response to those complaints, management, of course, began its enforcement process. 2 warning letters were sent to the tenant, and the tenant's response was that one of the dogs was a 6-month-old puppy and the other dog was a service dog. And he essentially asserted that his dogs were allowed to make noise, that barking was their natural behavior. Well, speaking of natural behavior, on top of the barking, there were 3 incidents where the tenant's dog attacked the corporation staff, attacked other residents of the corporation and other residents' dogs as well. So the corporation continued to receive further complaints, and so they referred the matter to the corporation solicitors, who wrote to the tenant, CCing the owner, and demanded the removal of the dogs from the unit. The tenant then failed to remove the dogs from the unit, and as a result, the condo commenced these CAT proceedings seeking an order for permanent removal of the dogs and indemnification for the costs that were incurred in enforcing compliance. And the CAT found that the condo's request for the removal of the dog was reasonable, especially in light of the logged complaints and the incidents of aggressive behavior from the dogs. So the CAT ordered the dogs to be removed within 7 days from the date of the decision. And because of the tenant's total disregard of the corporation's rules with respect to pets and nuisances, the CAT found that this was actually an exceptional case for the awarding of legal costs and ordered the tenants to pay approximately $8,400 in costs to the condo. And the owners were also ordered to pay approximately $2,600 in costs to the condo. And given that the CAT's normal rule is not to award legal costs, I would say that's a pretty high cost award in a CAT decision. So I want to give you 4 main takeaways from this case. Number 1, the importance of having complaints independently verified and documented cannot be stressed enough. It greatly benefits the corporation in the event it's forced to pursue compliance in the CAT. So the security guard in this CAT case testified, and he said that upon receipt of a complaint, he would attend to the unit floor, he would ask the tenant to address the noise, and then he would do up a written report attesting to what he heard when he attended the unit. And so this was critical, and it was critical to the corporation's success in this case. But in cases of compliance in the CAT, you should paper up and you should build your file when you have to enforce compliance. And just a tip, give your security guards detailed post orders. A post order is basically an instruction to your security guard as to what they should be doing in response to a resident complaint. The second takeaway is about service animals in general. So everyone is kind of quick to claim that their animal is a service animal, but the CAT in this case found that it didn't really matter because the tenant didn't provide any evidence of his dog being a service animal. So having evidence proving that your animal is a service animal is crucial, but also the CAT said even if this resident had proof that their animal was a service animal, it didn't even matter because it didn't alleviate the resident's responsibility to ensure that his pet did not create a nuisance. So basically in this case, unreasonable noise prevailed over accommodation. The third takeaway, when you have a clearly demonstrated enforcement procedure and a linear enforcement process, and the resident still blatantly disregards the corporation's request for compliance, that can constitute an exceptional reason to award legal costs in the CAT. So that's very important. And lastly, this is more for owners. If you own a condominium unit and your unit is tenanted, make sure that you're taking all steps possible right from the very beginning of a dispute to ensure that your tenant is complying with the rules, or else you could possibly be stuck holding some or potentially all of the legal cost in the dispute. So that's Chong.
And I really liked your comment that unreasonable noise takes precedence over a duty to accommodate. I think that'll be music to the ears of anyone who's living next door to a noisy dog.
Yeah.
Ben, let's talk about good practices to follow when you're going before the CAT. What can you tell us about that?
All right. Well, thanks very much, Megan, and happy holidays, everybody. So I want to talk about the Russell case, Russell and York 50. And yes, Megan, I do want to focus on an issue in that case about good practices with keeping minutes, and in particular, in-camera minutes. Now, the Russell case, in that case, Mr. Russell requested about 14 sets of records over 4 different records requests. So there was a lot of stuff going on in the case. Just to give you sort of a flavor of the sort of things, the issues that were that Mr. Russell brought up were, for example, the condominium corporation was installing security cameras. Mr. Russell insisted that there ought to be a bilateral contract for the installation of the security cameras, so that you need a written contract with all the terms set out, both parties signing the contract. Mr. Russell seemed to be of the view that every transaction that the condominium corporation entered into needed to be memorialized by a bilateral two-way contract. Now, we know that doesn't make sense. We know that no condominium corporation, no business memorializes every transaction by way of a two-way bilateral contract. And we even know that the law recognizes the fact that a contract doesn't have to be memorialized in writing with both parties signing. So the tribunal did find that it was enough that the condominium corporation had work orders, invoices, and board minutes where the corporation okayed the work. Just to give you a little bit more flavor of some of the things that Mr. Russell was asking for, there was a law firm that had provided an opinion. Mr. Russell wanted records regarding the termination of that law firm, and the corporation said, well, there are no records terminating the law firm because we just asked for an opinion. We got the opinion, and that's all we needed. Again, Mr. Russell seemed to insist that there ought to be some sort of, I guess, two-way bilateral contract or some record saying, okay, well, we're not going to use the services of this lawyer anymore. For those of the managers in the audience and the board members who work with lawyers, you know, lawyers don't work that way. Sometimes you requested for something on a one-off basis, and you provide it, and that's it. So that was like to give you just a flavor of a lot of the things that Mr. Russell brought up. But what I want to focus on is the area of the case where the tribunal did find some fault with the condominium corporation. The tribunal faulted the corporation for a few things with respect to the minutes. But in particular, what had happened was the corporation was keeping two sets of minutes. So it was keeping sort of an ordinary set of minutes and an in-camera set of minutes. So in the in-camera minutes would be where the board is discussing all of those things that unit owners would not otherwise be entitled to see. For example, discussions with respect to specific units, discussions with respect to contemplated litigation, or discussions with respect to employees. So those were kept in so-called in-camera minutes. Now, the tribunal faulted the condominium corporation because in responding to Mr. Russell's records requests, the corporation gave Mr. Russell the standard minutes, so to speak, but it didn't give him the in-camera minutes, but it didn't tell him that there were in-camera minutes. And the tribunal said, well, you should have said that there were in-camera minutes. Now, the other thing that the tribunal mentioned, and this is what I want to sort of just use my last minute on, is that it didn't say that it was wrong to keep in-camera minutes, but it did suggest that maybe that's not a best practice to keep in-camera minutes. Now, when I saw that, I'll confess, over the years, I've never really come down strongly on either side as to whether a condominium corporation should keep two sets of minutes. I am aware that it's a practice of a number of managers that they will do that they'll keep a set of in-camera minutes so that it just makes responding to records requests easier. Now, as I said, the tribunal didn't say you can't do it, but it seemed to fault the condominium corporation for doing it, suggesting that maybe it wasn't the best practice. But after having seen this case, and after having seen the now mandated procedure for requesting records, I would actually suggest that maybe it's not a bad practice at all to keep a separate set of in-camera minutes, because when an owner requests the record, the minutes, they're entitled to them. But under the new procedure, obviously you have to give them the minutes within a certain amount of time. If there's things that the unit owners aren't allowed to see in the minutes, you redact them. And it just strikes me as a far more efficient way of dealing with records requests under the now mandatory procedure is to have a set of in-camera minutes so that you can say to an owner requesting the minutes between a certain date range, okay, look, here's the so-called ordinary minutes that we'll give you. We also have in-camera minutes on these certain dates. We're not going to give them to you unless you want to pay us to redact them, and then you'll get a set of minutes that looks like it's out of the X-Files, all redacted, but at least you have them. So that's York 50 and Russell.
Thank you very much, Ben. And we have a slide which shows us the names of, it'll show you the names of the cases we just spoke about. So I'll ask our administrator to flash this slide up on the screen. These are the CAT cases that we told you about today, in case anyone wants to read a little bit more about them. And now I am going to ask the panel to give us their thoughts on the CAT. But before we go there, I want to run an audience poll. And do you think costs should be awarded to the successful party in the CAT? This is a yes or no question. And we want to get your thoughts on this question because I think one of the speakers has a few comments about this. So just beside the Q&A tab at the bottom of your screen, give us your thoughts on this. Now, the CAT has been active for a few years, and I'd like to ask the panelists to tell us some of their thoughts and experiences that they've had at the CAT. And I'm going to start with Anne.
Thanks, Megan. So the CAT, is one of the first Ontario tribunals that adopted a completely virtual or online process. All of the stages can be completed virtually. And that's meant to be like low cost and a quick way to resolve disputes out of court. Now, one really big positive thing that's come through during the pandemic is that services didn't halt, unlike the Landlord-Tenant Board, Human Rights Tribunal, or the small claims. So even though some of those other services have reopened for some of the other tribunals, there's a huge backlog, whereas applications at the CAT have continued to be processed steadily despite the pandemic, because everyone can work from home, make submissions virtually. So it's been smooth to that extent. Yeah.
Yeah, I agree with you. I know the small claims court in particular just couldn't cope virtually, and it's been very frustrating for a lot of litigants.
Right.
Ben, tell us some of your thoughts.
Yeah, well, I do have some suggestions where the CAT can be improved. I just want to be very clear. I think that the CAT's a great idea. It was a long time in coming. It's a good forum to resolve the kinds of disputes that it's taken jurisdiction over. It's a good forum to resolve them efficiently. The adjudicators are competent and well placed. But I have 3 suggestions to improve the process. First of all, I think that they should give some consideration to making it more difficult for one of the litigants or one of the parties simply to contact the adjudicator directly with a request. So we know that in normal litigation, for example, if you're arbitrating, and I've been in cases where I've seen my colleagues do this, and I don't think it's a good practice. And there's case law that says that you shouldn't contact the adjudicator unilaterally without notice to the other side. And there is actually case law that says the problem with doing that is where a party does that. It's essentially the same thing as bringing a motion without notice. And that's not proper, because without notice motions are reserved for very specific circumstances. So in the CAT, what can happen is a litigant decides that they want to raise a procedural concern. The next thing you know, they've contacted the adjudicator directly. You haven't had a chance to react, but now there's a timeline set for it. It would be more efficient, I would submit, if the parties dealt more with each other like normal litigation, where you discuss these issues and see if they can't be resolved before the matter is brought to the tribunal. Because processes like that, when you keep parts of the dispute out of the tribunal, you make things more efficient, you keep costs down. The other thing that I would suggest, again, it's a great tribunal, but just in terms of improvement, is perhaps for some of the more complex cases to require the parties to provide some sort of statement of issues. And my thinking on this is once again, if we look at court, if we look at arbitration, you know that you bring a notice, you make a claim, you have a pleading that sets out the parameters of your dispute. And there's a good reason behind that. It's because the other party who you're suing knows the case that they have to meet, right? And so I find that in the tribunal might benefit from a procedure like that, so that a party just doesn't start a proceeding in the tribunal and then keeps morphing what they're looking at as the matter goes on. And quite frankly, I mean, that makes it more difficult even to resolve an issue, right? Because if there's a mediation process in the CAT, if you can't resolve things there, you go through the dispute. But if things keep morphing and you keep having to change the case that you have to meet, once again, greater costs, less efficiency, and quite frankly, it's not a fair way to litigate. And then the last area that I would suggest might be improved is timetabling, the concept of timetabling. And this sort of goes back into my first point about litigants contacting the tribunal directly without notice to the other parties. And I know I've spoken to a number of my colleagues who sort of share my experience in the tribunal, that you're doing a case and the next thing you know, we all have incredibly busy caseloads and case schedules, but the next thing that you're preparing for an urgent injunction. And then the next thing you know, within 2 days, you have to answer this motion about the relevance or introduction of documents. So I would suggest that, at an early stage in the case, more timetabling, once again, would lead to greater efficiency, less cost, and quite frankly, more fairness in litigating cases through the tribunal.
Yeah, Ben, too, I have heard similar issues where busy lawyers get these deadlines that wouldn't be issued in a court case, and they can be challenging when you're trying to juggle lots of different things. So, Francesco, before I turn to you, I am going to take a look at the poll results. We launched a question. Do you think the CAT should be awarding costs to the successful party? 25% of the people answering said no. They like the no-cost system. And 3/4 of you thought yes, the successful party should be getting their costs in the CAT. So on the issue of costs, Francesco, tell us your thoughts.
So I'm going to answer the poll too. First thing, my thoughts are, I'm going to agree with the majority here. I think legal costs should be awarded in CAT, and particularly because I think condos are a different type of entity altogether. Remember, all owners contribute to the common expenses, and they're all jointly responsible for the costs that are incurred by the corporation. That's why I think that the complying unit owners shouldn't have to subsidize or bear the cost incurred by the corporation for having to go after a non-compliant unit owner. I don't think that's fair. And the awarding of legal costs in compliance cases really addresses that issue. So on the topic of cost and CAT, just an important thing to remember is the recovery of legal costs in CAT is the exception. It's not the norm. So this is different from the olden days in compliance cases in court, where a party could just expect to receive some of their legal costs just because they were successful in court. But legal costs are generally not awarded in CAT. And so condos should always consider ways to resolve a case prior to CAT, so they aren't spending a lot of money on fees that are not recoverable. But you can't avoid CAT in every case. So what can you do to maximize the potential for cost recovery? Like I mentioned in the Chong case, you can document and independently verify your complaints. You can send written notices from management prior to escalation, solicitors' letters prior to escalation. And ultimately, I think the general rule is just act reasonably when you have to enforce.
Thank you. Yeah, no, that's certainly good advice. And it's unfortunate that anything needs to go to the CAT to be adjudicated, really. You know, one of the things that I have very much appreciated about the CAT is that it has a process for obtaining records. Now, some of you may remember before the CAT, if an owner was entitled to records and they weren't getting them, they had to go to small claims court and fight an entire lawsuit to get records. And that was frustrating and slow, and it got expensive because a lot of owners and boards didn't feel comfortable being in court without a lawyer. So with the CAT, I find many participants can navigate the process with little assistance from counsel. So this is going to bring us to our next audience poll. Do you think records requests have become easier to handle since the CAT was created? We would like to hear your thoughts on this. I don't know if you've dealt with records requests before and after the CAT, but certainly let us know if you like the records process through the CAT. Now, going back to the issue Francesco was speaking about on costs, I find the issue of costs is universally important to condominiums, directors, and owners alike. And I want to turn now to some Superior Court cases on costs. There's one case that I wanted to highlight. This is Toronto Standard 1724. This was it was a case on Cci-Tech, and I think many boards, well, if your condominium was built in a certain time frame, you may have dealt with this, where you're doing a Cci-Tech project, someone doesn't comply, the condominium ends up incurring legal costs and Cci-Tech replacement costs. And in the 1724 case, the condominium was very successful in getting all those costs back from the affected owner. So if you're facing that kind of a situation, I don't know if the Cci-Tech has all been removed by now, but I would encourage you to take a look at that case. I am now going to turn back to Francesco. I understand that you have some comments. You were involved in a particularly complex lawsuit, and tell us about that.
Okay, yeah, so I'll talk about Tscc 1466 versus Weinstein. This is a series of decisions involving an owner of a condo unit who persistently refused to replace their Cci-Tech piping. I think the condo is still in litigation with the owner, but I'll talk about some of the decisions at the lower courts, since they provide some good commentary on some important issues. Although this is a Cci-Tech related case, I won't be talking much about the Cci-Tech aspect of it, but I will give a little bit of a factual history. So this owner failed to comply with their maintenance and repair obligations. Essentially, they failed to complete the Cci-Tech replacement in their units. And after lots of attempts of trying to get the owner to replace the Cci-Tech, the condominium eventually commenced mediation and arbitration proceedings against the owner in accordance with Section 132 of the Act. So without getting into all of the nitty-gritty details, the owner really frustrated the mediation and the arbitration process. And the arbitrator found that the owner's refusal to replace his Cci-Tech piping was unjustified, and his attempts to frustrate the mediation and arbitration process led to the incurring of very significant costs for the condominium corporation. So the arbitrator ordered the owner to pay over $60,000 in legal costs to the corporation, and also ordered the owner to replace his Cci-Tech piping. And so even after the arbitration, the owner still refused to replace their Cci-Tech piping and also didn't pay the $60,000 owing. So what did the condo do? They placed a lien on title to the unit for the $60,000 owing. The owner, of course, objected and said that the lien was invalid because in order to lien, you need a court order. So in other words, the owner's argument was that you could not lien for cost ordered in an arbitration. You could only lien for court-ordered cost. And that argument is really based on an interpretation of the Amlani case, which Ben will talk about. A lot of people tend to think that the Amlani case stands for the idea that you can't place a lien on a unit without a court order. And I think Ben will tell you why that's not true. But anyways, because the owner failed to comply with the arbitration award, the condo commenced a court application to enforce that arbitration award and to validate the lien that they had registered on title. The court upheld the condo's lien as valid and awarded full indemnity costs to the corporation in the amount of approximately $70,000. So the owner was dinged with approximately $60,000 in arbitration costs and an additional $70,000 in court-related costs. And I won't bore you with all the details as to why the judge ordered such a high amount, but there are really three main takeaways that I want you to know from this case. The first takeaway is you don't always need an official court order to lien a unit for legal costs. The court confirmed in this case that the condo was well within its rights to register a lien for unpaid costs ordered in an arbitration. The second takeaway is when you proceed to litigation, even after you get a successful result in your hand and you have the arbitration decision, you always have to factor in what your next step will be if the owner doesn't comply with that decision. When you proceed to arbitration and the owner still doesn't comply, then you have to take your arbitration decision and then have it enforced in court. And in the next section of this webinar, we'll talk about what happens if someone fails to comply with the court order itself. The third takeaway is, and this is very important for anyone in a litigious dispute, conduct that is deliberately obstructionist, vexatious, improper, that type of conduct is really, really frowned upon by the courts and can lead to some very adverse cost consequences. And this is relevant, especially in CAT, where some condo owners or corporations may be representing themselves more frequently. Be sure that you're always respectful, you're following all directions given to you by the adjudicator, you're complying with the rules of practice, and really just don't give the adjudicator any opportunity to criticize your litigation conduct.
Thanks. That's really good advice, Francesco. So I'm going to announce our last poll. It was are records disputes easier in the CAT? 2/3 of you have found that yes, and 1/3 thought no. You liked the small claims court process better. So that's interesting. With that, we're going to put our next poll on. And going along with Francesco's case, what percentage of legal costs do you think a successful party should get in litigation? And we've picked a few random percentages: 50%, 66%, 75%, or 100%. So I'll ask our staff to put our slide up with this poll so you can see it there and answer it. Thank you very much. And while you're doing that, I'm going to turn to Anne. I understand you have some comments about a resident and some particularly outrageous behavior.
Right. And that's the case of MTCC 1025 and Hui, if I'm saying it right. And this case involved, again, a tenant who had pretty, like you said, outrageous conduct, which led the condo corporation to obtain a compliance order against both the unit owner and the tenant to comply because of breaches to Section 117 of the Act. There was also a substantial cost of award against them. So in this case, it only spanned a couple of months. The tenant moved in May 1st, 2021. By mid-June, the tenant had engaged in the threatening and disturbing behavior until he was arrested in August and no longer on site. And during those short 4 months, the tenant managed to threaten a security guard with a knife, expose himself and perform lewd acts on the common elements, let his guest deal drugs on the condo premises, attempt to force his way into a resident's car and a contractor's van. He defaced unit doors and nearby walls and set up a chair and blocked the entrance of the building and didn't allow residents to enter. He also broke a window in the unit and threw his belongings out of the window. So, I mean, with that sort of conduct, the court absolutely granted the condo its compliance order under Section 134 of the Act to enforce compliance. The court was certainly satisfied that this tenant had breached the condo's rules, declaration, and 117 because the tenant's conduct caused or likely caused damage to people and property. And he was also in breach of the Occupational Health and Safety Act when the misconduct was directed against the condo staff. But a question came down, a common question always comes down to who's responsible for the corporation's costs of the application. So in this scenario, the unit owner had cooperated with the corporation. She had cooperated as soon as she was notified by the corporation in early June or so. So she delivered the appropriate landlord-tenant board notice and had applied to the landlord-tenant board for an urgent hearing. But this is all during the pandemic. So the owner's request for an expedited hearing was denied, and there was no date for the eviction at the hearing at the time of this decision. So the owner was kind of left in limbo. She had exhausted her landlord-tenant board options as a landlord, and she had also agreed to pay for some of the additional security guard costs to specifically monitor this tenant. The condo had argued that it was required to incur the costs of pursuing this application to get compliance. It was successful, and its governing documents provided that a unit owner had to indemnify the condo corporation for cost, damage, injury caused by any acts or omissions or breach of rules by its resident or occupant of the unit. The unit owner had argued that she shouldn't be personally liable for any cost award. It should be her tenant, because she had fully cooperated with the corporation and took immediate steps to have the tenant evicted. But her request for an expedited hearing was denied, and she also paid for added security. So while the court sympathized for this unit owner for cooperating, and she did all the right steps to have her tenant removed as soon as possible, the court did determine that it was unfair to the other unit owners to be responsible for the cost of the application, which was required for one person to comply. The court also found, the court also awarded $10,000 for this application. It wasn't cheap, and payable by the unit owner and the tenant jointly and severally, which means the condo can pursue the costs against either one of them, and then it's up to the tenant and the owner to sort out the respective portions. So in this case, likely the unit owner will be stuck with the entire bill unless she can recover some of the costs from her tenant. So the takeaway from this case is that unit owners are ultimately responsible for their occupants' conduct, even when they cooperate and they take reasonable steps to obtain their tenants' compliance. And given, the cost award in this case, it reflects the common framework or the longstanding framework that protects the innocent owners in the community, because it's not fair that they pay for one person's bad conduct. And it also signals to condo corporations that they should notify owners early when there's a problem or rule violation with a tenant, so owners have an opportunity to take the necessary steps to resolve the problem. And if it doesn't resolve and the corporation has to go to court, it will help the corporation in their cost recovery efforts.
Thank you, Anne. Anyone who is renting their unit will certainly be nervous when they hear the results of that case. Now, I want to turn to the audience poll. We asked you, what percentage of legal costs do you think a successful party should be awarded? 3/4 of you thought the courts should be awarding 100% of the legal costs to the successful party. 15% thought they should get 75%. And only 10% of you thought there should be about 50% of the costs recovered. Now, interestingly, in the court system, about 60 or 66% is granted to the winner. And barely any of you agreed with that percentage. So there you go. There's a disconnect between the people and the costs that are being awarded in the courts. Now, I do want to give you another poll. Going back to the case Anne just told us about, do you agree that the unit owner should have been responsible to pay the costs in that situation where they fully cooperated, yet they got hit with the big bill? So while you're answering that poll, I want to go to Ben and the notorious case of Amlani. And I don't think there has been any case that has shook the condominium legal community like this Amlani case. And Ben, tell us about it. Tell us what it says about charging back legal costs.
Yeah, thank you, Megan, and that's why I'm grateful for the opportunity just to say very quickly, editorialize about the Amlani case, because I do remember when it came out too. We got a lot of questions. Oh my goodness, we can't lien for legal costs anymore. We can't do chargebacks anymore. And I thought, oh geez. And I looked at the case, and the case doesn't say that. As Francesco mentioned, Amlani does not say you cannot lien for legal costs. It does not say that you can't do chargebacks anymore. Now, there's a lot going on in the case. I want to cover two cases in the next 2 minutes, so I'm just going to zero in on the issue about cost recovery. So it doesn't say you can't charge back legal costs. What happened in the Amlani case is the unit owner was smoking. The corporation incurred some lawyers' fees, and they tried to charge back the lawyers' fees. So what the court did is it looked at the act, and the court said, okay, look, in the act itself, I don't see anything that allows you to recover legal costs for enforcement mechanisms short of a court order. That's fine. That's as may be. And then they said, okay, now I don't see anything in the act. Now I'm going to go look in the declaration. And in that case, the condominium corporation was relying on the indemnity provision, which you'll see in probably like 90% of declarations. And that indemnity provision talks about losses and costs in relation to the units and the common elements. And so the court said, well, look, the guy's smoking. You're trying to stop him from doing that. Your indemnity provision doesn't cover that. And that's all the court said, right? So in my view, the only thing that the Amlani case represents is two things. Number one, some party made a really gutsy argument and the court didn't agree. And number two, if you want to charge back legal costs without a court order, make sure either that the indemnity provision in your declaration is more broad. And in some of the newer corporations, we're seeing more broad indemnity provisions. Make sure you have costs covered in a bylaw that says that you can recover them. Make sure that you have a good rule that says if you breach the act declaration or rules, you can recover costs. So for me, that's the takeaway to the Amlani case. And the second case that I want to talk about with respect to the costs is the Tomedio case. And the Tomedio case is in two parts. It was a compliance application, and then there was another application that I acted on for Ms. Tomedio to challenge the costs. But with respect to the application part of the Tomedio case, the case itself was noise and nuisance. There was a complaint that Ms. Tomedio's stepdaughter, who was living in the unit, was causing an uproar. Nothing even close to the case that Anne spoke about, but the condominium complained about it nonetheless. But here's the important part. Before it got to court, the condominium corporation put a lien on Ms. Tomedio's units for the legal costs that its lawyers charged the condominium corporation for writing compliance letters to Ms. Tomedio and her tenant. Ms. Tomedio, through her lawyer at the time, brought a counter application to court and asked the court to declare the lien invalid. The court said, no, the lien is valid. So why do I bring that up? Because in my mind, that supports what I said about the Amlani case. All the Amlani case says is the declaration provision that they were relying on wasn't broad enough. But it doesn't mean that you can't lien for costs if you have a properly worded declaration indemnity bylaw or rule. Now, that's that. But with respect to the Tomedio case, I wanted to talk about sort of the second part. The condominium corporation was successful against Ms. Tomedio, and it was a Section 134 application. So we know that under Section 134 of the Act, where a condominium corporation is successful, as Megan just said, when a party is successful at court, you can generally expect to get about 60 to 66% of your costs. But what the Condominium Act says is, okay, once you get your award of costs, you can add on all of your costs, and you can lien for those costs. And that's what the Condominium Corporation did in this case. But there's another principle out there, and that's not that when you have to pay costs, you can have those costs assessed. And where you have to pay another lawyer's costs, and it's not your lawyer. There's a special procedure for having to get those costs assessed. And when enough time goes by, you need the court's permission to assess those costs. So that's what Ms. Temedio did. The Condominium Corporation, I think, was asking her to pay about $80,000 in costs. Ms. Temedio applied to the Superior Court, and the Superior Court said, no, I'm not going to let you assess the costs. So we went to the Court of Appeal, and the Court of Appeal said, absolutely. Ms. Temedio can assess those costs. And what it said is, it said, look, it said, here's why Ms. Temedio is allowed to assess the costs if she can show a good reason why she should assess the costs. And the Court of Appeal said the good reason is this. When you look at the application that was brought against Ms. Temedio, you were complaining about noise and nuisance. It didn't even reach anywhere close to the tenant that Anne was speaking about. It didn't reach anywhere close to the unit owner that I'm going to be speaking about in a few minutes. But the corporation pushed all through the case to have Ms. Temedio sell her unit. And the Court of Appeal said, look, the Condominium Corporation spent $80,000 pursuing that strategy. And at the end of the day, they weren't successful on that strategy. So I get that Ms. Temedio is responsible for the costs under Section 134 of the Act, but she shouldn't have to pay all the costs for an unsuccessful strategy. So therefore, she's allowed to assess the costs. And the assessment procedure, what will happen is it will go in front of an assessment officer, and the assessment officer will look through the bills and figure out whether the charges are reasonable for any variety of reasons, with the potential to reduce the bill. As the CAT expands its jurisdiction, I know Megan mentioned this to me when I was speaking about this case to her before the seminar, as the CAT expands its jurisdiction, it may become less and less of a consideration as to whether costs ought to be assessed. But I would just say this takeaway, both, quite frankly, with respect to the Amlani case and with respect to the Temedio case, and with respect to our discussion with respect to costs, is the takeaway is this, is I think it's really important that when condominiums are litigating, that they remain cognizant of the fact that you shouldn't make the case about costs. And I get that there's a political aspect to costs, because the board members who are elected by the unit owners are put in this difficult position where the Act says they have to enforce the Act. To enforce the Act, you have to incur costs. And they've got all their neighbors who elected them saying, what are you doing spending our money? So I get that there's a political aspect to it, and it's difficult to face your electorate when you're spending a lot of money. But the court keeps sending messages out there to condominiums. Don't make it about costs. Make it about the mischief that you're seeking to prevent. Because if you make it about costs, you really run a very high risk that it can go very badly against you.
Thank you, Ben. I agree. I think in the pursuit of cost recovery, people can lose sight over what they're really there about and what brought them there in the first place. I'm going to take us back briefly to our audience poll about Anne's case, where a landlord ended up being responsible in $10,000 in costs. 75% of you thought that was fair, and just 25% didn't like what happened there. So I think cost recovery is the theme of this group. And I saw our staff had put up the next poll. Question: do you think condominiums should be able to levy fines for breaches of the rules when you've got bad behavior? So let us know your thoughts on that. Now, I think it's fair to say that all of us have been affected by the pandemic, and maybe some more than others. I think a lot of us who work in this industry, we've seen bad behavior in the pandemic, and it really seems to have been escalating recently. And, I've certainly seen reports on mental health all over the news. And I know a lot of condominiums have been before the courts now. They've gotten orders telling owners behave, and owners just go on to ignore and breach these court orders, which is not something that I saw a few years ago. So we're going to turn to the issue of enforcement and enforcement of court orders. And Ben, I'm going to go back to you. What experience have you had getting owners to comply?
All right. Well, let me. I've got a war story lined up for you, and it's a case that I recently completed from my mouth to God's ears, right? And it was a condominium in Pickering, and a unit owner named Mr. Auer. Now, a couple of years ago, before the pandemic, Mr. Auer was playing his music, far too loud. He was yelling. He was swearing. It wasn't good conduct. It wasn't the immediate conduct where the court would say, "Okay, listen, I'm immediately going to tell Mr. Auer to sell his unit." But I think it was certainly conduct that warranted a court application. So the Condominium Corporation brought a court application at 0 hour. Mr. Auer retained a lawyer, and he consented to a judgment. So the fact that he consented isn't as important as the fact that it was a court order. So the court ordered him, behave yourself. Now, a couple of years went by. Mr. Auer started up his conduct again. And so I have a court order that says he's not allowed to do that. So what do you do? Well, what you do is you bring a motion under the contempt rules to have that owner, to have Mr. Auer found in contempt of court, and to have the court order appropriate remedies. Now, the important thing about this is jail imprisonment is a very real remedy for contempt of court. There's a bunch of other stuff too, and I'll tell you. But we tend to think that wow, going to prison, that's like really extreme. We're in condominium corporations. We've got people misbehaving at it all the time. The lawyers in this panel know how to deal with folks like that and get appropriate orders. But jail isn't always sort of in the contemplation of parties. But the Auer case proves that it is a very real possibility. And so it's really important that owners, when there's an order against them, that they comply with the order. Because what happened is I brought a contempt motion. It wound its way through a couple of procedural case conferences, but with the court always agreeing that the matter was urgent. And finally, the matter came on for hearing, and it was scheduled before His Honor Justice Sharma. And I think about 2 days before the hearing, I received an email, as did Mr. Auer, from Justice Sharma. And Justice Sharma invited us to be prepared to make submissions as to whether Mr. Auer should not be arrested and imprisoned immediately, because it looked like he was in contempt. And so I got my submissions together, obviously, to be prepared to make that argument. When the day came, Mr. Auer actually didn't show for the hearing. And Justice Sharma did, in fact, order that a warrant should be issued for Mr. Auer's arrest. I had the warrant issued, and because it was urgent, and to avoid the lag that sometimes occurs with process servers, I myself drove the order out to the police in Durham, and Mr. Auer was promptly arrested, and he was imprisoned. And he was imprisoned for about 5 or 6 days. Now, when Mr. Auer was released from jail, the hearing came back on so that we could deal with all the issues. And the end of it is that Mr. Auer was ordered to sell his unit, and the court gave me 100% indemnity costs. So that's 100% indemnity outside of the operation of the Condominium Act or any of the rules, or that sort of thing. Now, I did make submissions that Mr. Auer should be further imprisoned. Justice Perel, hearing the case, suggested that he wasn't going to imprison Mr. Auer further because the best idea was to get Mr. Auer off the property as quickly as possible. And if he was sent to jail again, that might impede the sale. And also, His Honor, as I said, ordered full indemnity costs. So using costs as a disciplining factor to Mr. Auer. But really, again, the takeaway is that prison is a very, very real thing if you breach a court order. And sorry, just the last part of my war story, you know, for those of you whom I haven't convinced and who think, you know, jail might be just such an extreme thing, on my way into the hearing in the Auer case, I happened to bump into a judge. I won't mention their name, but that judge asked me what my matter was about, and I explained what it was about. And that judge told me that, oh, well, that's very interesting because I just did a contempt case and we ordered 20 days in jail for a breach of an order. So takeaway, obey orders, or you can absolutely go to jail. It's a very real remedy.
Well, that's news to me. I suspect that will be news to many. And you know, there may be some people listening to this seminar who know of an owner who maybe should have been put in jail, but, you know, we'll just leave that. So I'm going to go back to our poll question on fines. You know, Ben, we've heard going to court, getting all this order. Wouldn't it be easier to just fine people if they kept breaching the rules? Now, the Condominium Act in Ontario doesn't allow fines, but 2/3 of you thought, yeah, we should be able to fine owners for breaches of these rules. Now, I know in 2022, smoking disputes are going to be going to the CAT, and we have yet to see how the CAT will handle them. But Francesco, tell us a bit about how the court has dealt with smokers who breach the rules.
All right. So I'm going to talk about Linhart. This is a case obviously handled by you, Megan. And as always, let's start with the facts. So Miss Linhart was a smoker. Condo passed a no smoking rule. And because Ms. Linhart was a smoker, she applied for a grandparenting exemption and she was granted one, and she continued to smoke in light of her grandparenting exemption. Now, part of the problem was that the unit owner residing above Mrs. Linhart's unit had a very severe allergy to smoke. And there was actually lots of evidence to show that this owner was being very negatively impacted by the smoke emanating from Ms. Linhart's unit. So the condo would receive frequent complaints of smoke. And what did they do? They attended Ms. Linhart's unit and they independently verified and corroborated the above residents' complaints of smoke. And when the complaints still continued after numerous requests to stop smoking, the issue was then escalated to the corporation solicitor, who then advised Ms. Linhart that her grandparenting exemption was being revoked. Now, even with the revoking of Ms. Linhart's grandparenting exemption, the smoke complaints still continued, and that necessitated a court application by the condo. And here, my friends, we have a very good example of a linear and well-established enforcement procedure, which greatly assisted the condo in this case. And in the court application, the court ruled that Ms. Linhart can no longer smoke in her condo unit. And based on the pattern of cases today, I bet we can all imagine what happened next. Ms. Linhart continued to smoke in her condominium unit. So the condominium corporation brought a motion for contempt of court, filed lots of independently verified evidence to establish that Ms. Linhart continued smoking in her unit. And Ms. Linhart even went as far as trying to mask the smoke odor with air fresheners, but that only made the residents' allergic reaction worse. So the court found that Ms. Linhart was in contempt of court, but they said contempt was a two-step process. So first, a finding of contempt has to be made, and it was made in this case. And second, once a contempt finding is made, then the owner has to be given an opportunity to purge their contempt. If they fail to purge or clear their contempt, then the judge can lay down a very, very harsh penalty, which, as you know from Ben, includes jail time. So in this case, a finding of contempt was made, but ultimately Ms. Linhart was able to purge her contempt by establishing that she had quit smoking. So despite her purging of her contempt, the judge still awarded the condo full indemnity costs, in part due to Ms. Linhart's, and I quote, flagrant, deliberate, and selfish failure to obey the court's order. And the full costs ordered on the contempt motion were approximately $17,000. So just a few takeaways. Again, just because a unit has a grandfathered status and it's exempt from a certain rule, doesn't give the owner the right to cause an unreasonable nuisance or a disturbance to other residents. In many cases, as we've seen here today, unreasonable nuisances could prevail over individual circumstances of one resident. The second takeaway is the idea of purging. You might think as contempt as a relatively easy step. You have a breach of a court order, you apply for contempt, and very serious penalty results. But it's actually a two-step process. In most cases, you will have to give the other party an opportunity to fix their contempt. And number three, I just want to highlight a section of the Act that I find is kind of underrated, and that's Section 117 of the Act. This is a very, very important section when we're talking about compliance and even contempt of court. I'm going to read it for you just quickly, just to give everyone an idea of what it says. It says, no person shall permit a condition to exist or carry on an activity in a unit or in the common elements if the condition or activity is likely to damage the property or cause injury to an individual. So where the corporation can put forward clear evidence of a breach of that section, courts are more likely to provide relief on a contempt motion. And that's because the last thing that judges want is for one person's behavior to injure another. This provision is broad. It can apply with respect to many issues like smoking, harassing conduct, short-term leasing, noise complaints. So always keep this provision in mind when you're enforcing compliance.
Thank you, Francesco. I think maybe the big takeaway for me on that case was that grandparenting status, it's not permanent. If it's a problem, it can be revoked. And I think that's important for directors to know about. Now, we have one more case to speak about before we get to our holiday draw and questions from the audience. If you do have any questions for any of the speakers, you can start putting them in the Q&A now. And before we get there, I'm going to turn it over to Anne. Tell us about a case that you found interesting this year in the contempt area.
Sure, thanks, Megan. So it's YCC 188 and Chowdhury. So this is a case involving a long-standing dispute between a condo and an adult son living in his parents' unit. So the dispute actually started back in 2016. That's when the compliance application was originally started. And the condo had obtained a compliance order because the son had sent threatening and harassing communications to the property manager, directors, and condo lawyers, contrary to Section 117, the section that Francesco had spoken about. And that 2017 order also included a prohibition that the son not attend at the management office, the homes of the directors, or act in any manner that was abusive or threatening. The court also found that the parents had failed to take reasonable steps to prevent their son's misconduct because they even signed letters of authorization approving the son's conduct in permitting him to act on their behalf. Okay, so but despite this 2017 compliance order, this didn't stop the son's conduct. The son continued his behavior despite even being charged by the police in 2017 for criminal harassment. The son continued his conduct until some point this year when the rest of the family stepped in and got the son to leave the unit. But by then, the condo had sought a further compliance order and a contempt order in 2021. And it was split up. It was heard as a compliance issue first and then a contempt issue second. So at the compliance hearing, the court found the son had breached the 2017 compliance order. He had continued to make offensive, discriminatory, defamatory, and threatening comments targeting directors for their religious beliefs. And he also had a pattern of bringing frivolous and vexatious administrative proceedings, including repeated baseless records requests to the board. So the court found that the son's conduct was persistent and unrelenting and warranted serious measures to prevent the reoccurrence of harmful conduct. And they granted a compliance order prohibiting the son from renting or occupying a unit in the condo, from even visiting or attending the property, approaching management, employees or directors or the condo's lawyers, or engaging in any sort of harassing or abusive conduct. Again, the court found that the parents, who are the unit owners, did not take reasonable steps to ensure their son didn't violate Section 117 of the Act, and costs were awarded against the parents. But then when it came to the contempt motion, which happened after, the court in this case declined to make a finding of contempt against the son. So the court's decision was based on two principles. One, that the court has discretion to issue a contempt order. A court may decline to make a finding of contempt, even if the elements of contempt have been proven. And secondly, that the purpose of the contempt order is to obtain compliance with court orders, not to punish. So the message to all here is that court orders must be respected and obeyed. So in this case, the court exercised its discretion and gave the son the benefit of the doubt because the son had stopped his misconduct, moved out, and promised to respect the terms of the court order. He also told the court that he had felt he had been heard, whereas in 2017, the son believed the order was obtained by fraud and appealed the 2017 decision and lost. But the court also left it open for the Condo Corporation to bring a further motion for contempt if the son violated the new compliance order. And the court warned the son that if he was subject to another contempt motion, he could find himself subject to a fine or jail time. And importantly, the court granted the condo its costs for the contempt motion because the condo had successfully proved the contempt, and there was no reason why the son should not have to pay the costs of the motion. So the takeaway for this case is quite simple. Contempt motions can result in fine, incarceration, and if not, a hefty cost award, even if a contempt order is not granted. So it's not worth disobeying a court order or gambling the results of a motion for contempt. Like, court orders must be obeyed.
Thank you, Anne. That's a really important message, and I hope everyone heeds it. So I want to thank our speakers for putting together all of their thoughts and joining us today. We do have some questions for you from the audience, but before we go there, we are going to do a holiday draw. So the first draw is for a $75 mall gift card, and I will ask the CCI staff to please spin the wheel and let us know who wins this prize. Mike and Joan Reed, congratulations. You will be contacted by CCI staff, and enjoy. Our second prize is a gift card for a grocery store so we can buy your holiday meal. And it is Diana Ionescu, and I'm sorry if I pronounced that name wrong, but congratulations. Now, our first question, I am going to turn it to Francesco. We had a question about the comments where the rules about dogs barking, superseded someone's duty to accommodate. And can you tell us a bit more about that and clarify your comments? Sorry, Francesco, you're on mute there.
My apologies. Okay, so I think that's a very good point, and I would like to address it. So it's important to remember that the Human Rights Code has primacy over all legislation. It prevails over the Condominium Act, it prevails over any other legislation, and it still prevails over all of that legislation to this day. And I don't see that changing anytime in the future. So the Human Rights Code does have primacy. However, under the Human Rights Code, the Condominium Corporation does have an obligation to accommodate up until the point of undue hardship. So let's take the example of the dog. The dog owner or the resident is probably entitled to accommodation based on their disability or whatever the case may be. So they're entitled to accommodation. They're entitled to have a dog because it's a service animal. However, just because they're entitled to accommodation based on any of the enumerated grounds in the Human Rights Code, it does not give the owner free will to sort of cause as much unreasonable disturbance or excessive noise as possible. In fact, I would constitute that as the point where the dispute turns into undue hardship. So the corporation has a duty to accommodate that owner up until the point of undue hardship. Now, regardless of whether something constitutes undue hardship, the condo still has obligations under the Human Rights Code to accommodate the owner both procedurally and substantively. So procedural accommodation means allowing the owner to explain what accommodation is required, meeting with the owner, basically having a dialogue with the owner to understand their accommodation and, you know, trying to make that accommodation a reality. Now, substantive accommodation means actually accommodating the person for what they're asking for. And it can include things like entering the owner's suite and seeing if there's any way that the corporation can attenuate the sound emanating from the suite. Now, if both the procedural and the substantive accommodations have been given by the corporation and the surrounding residents are still experiencing noise issues, then at that point, it likely constitutes undue hardship to the surrounding residents. And at that point, the condo probably can and should be enforcing the rules as against the owner, notwithstanding their accommodation status. So it's sort of a sliding scale. You really have to assess whether you've satisfied your obligation to accommodate. And if you have, and the complaints are continuing and they're causing a disturbance to the surrounding residents, then at that point, the condominium corporation should be enforcing their rules.
Thank you, Francesco. The next question is going to come to Ben, and this is a question about the production of minutes, which I guess relates to our discussion about the CAT. So the corporation can charge for redacting minutes. The question is, can the corporation charge more than once for redacting the same set of minutes?
Well, it's a question of fact, really, right? Because costs, a condominium corporation, quite frankly, and I don't want to go too far outside the question, but whether the condominium corporation is charging for redacting minutes or charging for anything else, costs are not in and of themselves a disciplining factor, right? Like we had that poll question earlier on, can a condominium corporation levy a fine? And Megan quite correctly said that under the Condominium Act, condominiums in Ontario can't levy fines. So well, why am I talking about that? Because the answer to the question is, can you charge twice for the redaction of minutes? Again, it's a question of fact. Do you have to, right? And I don't know if you have to. Maybe you do, maybe you don't. If you do have to go through the process for whatever reason of redacting the same set of minutes another time, then yeah, you can charge for it if you really have to incur those costs. If you don't have to, no, you shouldn't be charging for it because, again, costs aren't a disciplining factor. They may have the effect, right, of being a disciplining factor, but from the condominium point of view, they're not.
Thanks, Ben. Yeah, and I think the records regime is not supposed to be a moneymaker for the corporation.
It's actually generally a loss leader too, right? So,
we did get a question about an owner's ability to refuse to pay a chargeback. And this involves where a corporation did an in-unit repair that the owner failed to make, and it was a non-emergency situation. And the question is, can an owner refuse to pay that kind of a chargeback if they weren't given an estimate first or an opportunity to get their own pricing? And I'm going to answer that question. And the answer is no. If you didn't do work that the corporation asked you to do, you've waived your opportunity to get your own pricing and get a hard estimate. So I hope where owners are instructed to do necessary work in their units, even if it's non-emergency, that you just do it. I think that would certainly help everyone. Now,
I would just add one thing to that. Under Section 92, Megan, you're absolutely correct. Under Section 92, you should give the owner a reasonable time frame to complete the work, and then if they don't, then absolutely you can go ahead. But just keep in mind that you can't insist that the owner do work one day and then tomorrow go in and do the work. You have to provide the owner with a reasonable time frame to complete that work.
Yeah, we like to assume everyone behaves reasonably, but Francesco, you're right. That's not always the case. So I am going to turn to Anne. We have a question about fireplace smoke. So this isn't cigarette smoke, but it is smoke going into people's units through the fireplaces. And the question is that question going to be dealt with at the CAT?
So most likely, yes. I mean, coming in January 2022, we're talking about odors, smoke, vapor. So this, even though it's not smoke odors, it could be cannabis or other scents even, but definitely fireplace smoke would fall under that category, and we'll likely see some sort of cases that aren't just smoking cases at the CAT in 2022.
Yeah, and even perhaps some restaurant cases, odors.
Right.
Looking forward to it. So I'm going to turn to Francesco. You spoke a case about Mr. Weinstein. What did he do to warrant such a high cost order against him?
It was really about his litigation conduct. I mean, he took a position on the CCI-T and he stuck with it, and that's one thing. But the cost award in the Weinstein case was mainly about his litigation conduct. Some examples are he sent numerous unsolicited communications to judges and provincial staff. He refused to comply with judges' directions and orders. He didn't really follow the prescribed process for civil court applications. He alleged fraud on numerous occasions without providing any proof or anything substantiating those allegations. He actually failed to attend the mediation and the arbitration, and he would just generally file lengthy, non-compliant pleadings, which required, lengthy responses from counsel. So just his litigation conduct led to a significant amount of cost. And the court found that his conduct was abusive, it was vexatious, it was obstructionist. And that's why I mentioned earlier in the seminar, it's very important to adhere to the court's rules of practice and just really be respectful throughout the litigation process. It could help in the event you're faced with a cost decision.
Thank you. Yeah, if only everyone was respectful all of the time. Would help us in costs and in other ways. Ben, I'm going to turn it over to you. And when we were chatting before the session, you were telling me about a recent decision you had on an Airbnb matter. And I'd like you to tell the audience about that matter.
Yeah, sure, absolutely. I mean, the decision just came down to us this week, and it was a decision that my associate Fatima Vieira did for us. It's Durham 39 and Colthurst, and it's about an Airbnb. There were unit owners who were running an Airbnb out east of Toronto. Now, originally, what happened is first we sent out compliance letters. Don't do your Airbnb. Don't do it. We brought the application, and the court actually ordered an interlocutory injunction against the owner, saying, listen, until the application actually gets heard, you got to stop running your Airbnb. First of all, the corporations identified that there's a real legal issue here. Are you allowed to do it under the single family use provision of the declaration? But also it's a pandemic, for goodness sake. And as Francesco just mentioned, Section 117 that deals with injury to individuals and people getting hurt is a very, very, very important and very powerful section. And the court said, well, yeah, I mean, it's a pandemic. You're running an Airbnb. I can't have that happening on the property. The application eventually came on for hearing. The unit owners tried to say, well, we didn't really know what the rules are. We're actually sort of providing a public service because of the surrounding community. And the court said, well, no, look, you were sent lawyers' letters. The lawyers' letters told you very clearly what was wrong, why you can't do it, and what will happen if you do. You have an interlocutory injunction that, by the way, you're in breach of. And so, yeah, I'm going to order that you can't have your Airbnb anymore. Most importantly, because the Airbnb is inconsistent with single family use of a condominium corporation. So, yeah, it just came down. I think it's a really good and useful decision. Cost submission, it's still sub juris. Cost submissions are still to be made, but it's a Section 134 application. So, you know, we've had a lot of discussion about those and costs today.
Well, thank you. And we have one more question for our speakers, and this question is going to Anne. You were telling us about the Metropolitan Toronto 1025 versus Hui case. And this was the case where the unit owner, who basically sort of complied, ended up probably paying the legal bill for their tenant's behavior. And the question is, does it matter whether the owner or the tenant is stuck paying the bill so long as the condominium gets its money?
Yeah, so it does matter because that relates to, you know, the post-judgment collection steps. So if the costs are payable by the unit owner, likely you'd get an order that it can be either applied to the common expenses, secured by a lien, and enforceable like a mortgage, versus having it enforced against the tenant who isn't at the unit, who doesn't have an address. We don't know if they have any assets. So ideally, yeah, having costs secured against a unit owner who has a unit that you can secure against more likely ensures that the condo corporation can actually collect the award that they've been given.
So I guess that goes with the old problem. Just because you get a judgment doesn't mean you're going to get the money.
Right.
Well, that is the end of our session today. I would like to thank everyone for joining us. We hope very much that we will see you in person next year at anything. And congratulations to our winners today. And I hope everyone has a very good holiday season. Everyone stays safe and healthy. Goodbye.
Take care. Happy holidays, everyone.
Thank you, everyone. Happy holidays.
Bye.